Hi, this is Brian Dolan with the law firm Pepper Hamilton. Thank you for joining us for this latest podcast. Today we're talking about labor and employment issues for investment management companies and hedge funds. Recently, Pepper partner Greg Nowak hosted a webinar for West LegalEdcenter. He was joined by fellow partner Richard Reibstein and Laura Kibbe, Managing Director of Professional Services at RVM Enterprises. Some of the major topics they discussed were the independent contractor versus employee status determination issue, what to do when a professional leaves your firm, and uses of the tracer analytic tools to protect your company against theft of intellectual property. This podcast is a recording of that webinar. You can download a copy of the PowerPoint slides from that session by visiting the Insight Center of Pepper's website at www.pepperlaw.com, where this podcast is posted.
My name is Greg Nowak. I'm a partner in the financial services group at Pepper Hamilton. We're a full-service law firm located across the United States. And I'm also a practice leader for marketplace lending and for hedge funds here at Pepper. So thank you for joining us. Today I am joined by two very distinguished speakers. One, Laura Kibbe, who's with RVM Enterprises, and I'll ask Laura to introduce herself.
Sure. Good afternoon. As I said, I'm Laura Kibbe. I am a managing director at RVM Enterprises, which is an e-discovery and consulting firm. I've been practicing for about 25 years, combination of in-house and outside counsel over that time.
And also joined by my partner, Rich Reibstein. Rich, you want to introduce yourself, please?
Yes. Hello. My name is Rich Reibstein. I'm a partner at Pepper Hamilton. I head the labor and employment practice here in New York City, and I am co-head of the independent contractor compliance practice of Pepper Hamilton. That's an interdisciplinary practice of of labor and employment, tax, benefits, and class action lawyers.
Thank you, Rich. Thank you, Laura. As you may have guessed from the introductions by our speakers, our topic today is focused on employment implications of those working in the investment management and funds industry. In particular, independent contractor and employee classification or misclassification. And then what do you do when an employee is suspected of having stolen financial intellectual property? And for that, we have Laura to join us as well. A quick housekeeping item, as Emily said, if you have any questions, please submit them and do not hold them to the end. We will address your questions along the course of the hour as they are presented. And then secondly, for those of you who have attended our programs before, we will be taking a hiatus during the summer. We will not have a investment management roundtable in June, July, or August, but we will be returning again in September. So hope to see you then. Okay, without further ado, let's talk a little bit about our topic of the day, which is independent contractor misclassification. Rich, what are the stakes here? Why do we hear people being labeled as contractors versus employees?
Greg, in the last 10 years, there has been an acceleration of the use of independent contractors by a lot of businesses, and furthermore, some businesses, especially in the Silicon Valley area, have begun to rely entirely in their business models on independent contractors. The most obvious one, of course, is ride-sharing giant Uber, but there's so many other companies like that where instead of using employees as part of their service providers, they are using exclusively independent contractors. But, Greg, it's not just those companies that have a business model that is dependent on the use of independent contractors or 1099ers. There's almost no business in the country that is not making some use of independent contractors and paying them on a 1099 basis. And it's really important to understand that using independent contractors is something that is permitted by law. And it's actually acknowledged by the Department of Labor, U.S. Department of Labor, as a legitimate use of personnel. But the problem, unfortunately, is that very few people, very few companies have structured and documented the relationships in a way that satisfy the legal test.
All right, so let's take a step back here. Okay, if I get a 1099 as an independent contractor, that means the IRS knows about me, and I'm going to have to report that probably on Schedule C of my tax return, and I'm going to have to pay taxes. And if I use any kind of a, TurboTax or something like that online program, it's going to drive me to pay self-employment taxes, et cetera. So whose ox is being gored here? Why does the government care whether or not someone is an independent contractor or an employee?
Well, there's two folks who care. One are the government, and I'll go into that shortly. The other are plaintiffs' class action counsel. Let's start with the government. You're right. If you give a 1099, someone who is compliant with their legal tax obligations will list that on their tax returns, and they will pay an appropriate amount of income tax to the federal government, including both halves of the Social Security and Medicare. But the IRS has stated many times that we wish that were the case. A surprising number of people who are issued 1099s don't pay, and many 1099 forms are not accurate. So obviously, the feds and also state revenue commissioners would love to have what we've established in this country a long time ago, where employers withhold taxes from the employees' regular pay and pay them over on a quarterly basis to the federal government and to the state government tax agencies.
So there's an implicit qualitative statement here by the government that the independent contractors in the main have a compliance problem.
Well, and quantitatively, they've identified that there is we're losing X billion dollars in tax money that we would otherwise get. But that's only part of the issue. You then have state unemployment insurance agencies who, quite frankly, don't understand why someone who should be classified as an employee but instead is getting a 1099 is not having contributions made on their behalf by the service recipient. They're saying, hey, you've got these 47 independent contractors there. We don't think any of them are really to be considered independent contractors under our tests in this state law, and therefore we want you to make contributions to the unemployment insurance fund on their behalf because our funds are depleted. We're giving out too much unemployment already.
But hold on a second. If I'm an independent contractor, I'm not eligible for unemployment claims, right?
That's correct. However, what we are finding is that the state unemployment agencies are taking a very aggressive position and saying, you're not structuring and documenting your relationships in a sufficiently compliant way, and therefore you may think these folks are independent contractors. We think they're employees, and we think you should be making contributions on their behalf and should have for the last 3 years.
So let's talk about the archetypical independent contractor, the lawyer and the law firm. So the lawyers work for the law firm. The law firm is engaged by a client to provide services. There's no question there that the law firm is an independent contractor of the client, correct?
That's correct, but let's even use a more archetypical one, and that is the plumber who has a
plumbing truck and a roto-rooter and everything else that he needs to run his business.
Right, but he's a sole proprietor. He just runs the business himself, and he does very well for himself. That is exactly the typical type of independent contractor that the government is not going to bother anyone about.
But when I call a plumber to my house, I don't have to give him a 1099 because I'm not in a business, right? Well,
you would if you engaged him sufficiently where your total amount of compensation for the individual is over $600 and the individual has a sole proprietorship. In other words, does not have a separate tax ID number for an S or a C corporation.
But I have to be in a business, don't I, in order to have to issue a 1099? I mean, I had a plumber come in and do work on my house and, was very chagrined to see the bill was $2,500. I don't have to give him a 1099.
Well,
I'm not in a business. It's for my home.
The IRS would say you need to give a 1099. Do homeowners give 1099 to people who are contractors and they pay more than $600 to? Rarely is that the case. But no, 1099 is not required only by businesses. It's required by anyone who's giving services of more than $600.
Okay, so let's move on. We understand why there is an advantage to the company to use independent contractor or to classify someone. Tell us about this class action stuff, the plaintiff's class action lawyers. How does that implicate here?
Let's just step back very briefly on the advantages. Why do people use independent contractors? Quite frankly, Greg, there's a lot of money involved because if you're not paying unemployment, workers' comp, you're not paying your payroll taxes, you're not paying any benefits because, quite frankly, ERISA doesn't apply.
If you're truly an independent contractor.
Yeah. And in addition to that, the labor laws do not protect you. You can't file claims for discrimination. You can't file claims for family medical leave, etc. So there's an imperative for companies to try to reduce their payroll costs. This is one that a lot of companies see as most beneficial. Now, that's also, there's other people in business, and the other people in business are plaintiffs' class action lawyers. They see that very few companies are out there structuring and documenting independent contractor relationships in a compliant manner. It may seem like, all you have to do is dot your I's and cross your T's. The problem is that the tests are so varied, and I would say they're not intuitive. And so there's a lot of facts that you would think would support an independent contractor relationship, but in fact the government is saying and the courts are saying, no, they actually support an employee classification. And so you're finding that no matter how sophisticated the company, they're misfiring. Misfiring is so commonplace that plaintiffs' class action lawyers have said, if I see a lot of independent contractors, they're probably being misclassified. And you know, Greg, how easy it is these days to file a class action lawsuit. You just need one potential class representative, and then you can bring it on behalf of all other similarly situated individuals. And if in fact you're correct and the company is not dotting their I's and crossing their T's correctly, then you've got a real problem for the company dealing with that class action. So it is what I would say a cottage industry now in the area of independent contractor misclassification, but there are ways by which companies can defend themselves.
All right, so hold on a second here. The plaintiff, presumably the representative plaintiff, is an employee, right? So what is he suing for in the plaintiff's class action? I mean, he received his 1099 wages. Is he suing for the fact that the government the employer didn't withhold? Or is he suing for the employer share of Social Security or benefits? Or what exactly is the class action case looking for? Because he's been paid whatever his agreed consulting was.
Well, class action plaintiffs, class action lawyers have sued for dozens of different types of claims. For example, under federal wage and hour law and also state wage and hour law, there's the issue of minimum wage and overtime. Especially overtime can generate very substantial amounts of potential exposure. So if you have a group of people who are working over 40 hours and you're paying them on a 1099 basis, you better hope that you've structured and documented that relationship well, because otherwise you have a very serious exposure. In addition to that, there's issues of benefits. If people are not properly carved out of ERISA plans that they can be carved out from, someone who may have a catastrophic illness may claim that, hey, I should have been covered under this employee medical plan, and therefore all of my medical claims should have been covered. In addition, there's issues of 401k, contributions. People say, hey, you're contributing to all the employees at 3%. How come not me? So there's a lot of federal and state claims there. In addition, one of the biggest one, Greg, is for those people who have a considerable amount of expenses, employee expenses. For example, drivers of trucks that are making deliveries and haven't been properly classified. They're spending a lot of money to maintain that vehicle, leasing it, buying it, fuel, maintenance, and operation. And so, for example, with FedEx Ground, who I think the FedEx Express are employees and the FedEx Ground folks are independent contractors, FedEx just had to settle a case in California for just the employee expenses, $226 million, Greg. So it can add up, and that was almost all expenses in operating the vehicle.
Yeah, and I mean, there have been several route driver cases over the years where firms have attempted to create independent contractors for their delivery people. And, invariably, I think they lose. I've never heard of one that actually ultimately was sustained. Have you?
Well, actually, there are, and distributors are one of those groups that are, in my view, well-positioned to be independent contractors. But, as we talked about before, you have to structure and document it correctly. And what do you do in structuring and documenting it? The most important thing of all, Greg, and the critical factor in most of the tests is going to be whether you exercise direction and control over the manner in which the services are performed. So if you've got a distributor and you're treating them as a 1099er, and you're also telling them how to perform their services, you just undermined the relationship as an independent contractor, because you're only really permitted to tell an independent contractor what to do, not how to do it.
Can I require them to wear a uniform?
The courts will allow uniforms in rare instances, and that's only for purposes of security and assuring someone that you make a delivery that you're actually the person from that company. So if you have a FedEx ground driver, and some of them have been found, by the way, to be independent contractors, some have been found to be employees, and you require them to wear a uniform so that the person answering the door is going to allow them entry, the courts have made an exception for that.
But other forms of when and how to organize your route, what repair shop to use, et cetera, anything like that erodes the case that they are, in fact, independent contractors.
Well, just to give you an example, if FedEx Ground said, we need you inside the truck that you own to have shelves that are at least 12 inches off the ground, and the next there has to be a recess of another 18 inches off the next one, now they're starting to tell you how to do the job. Instead of just hiring someone who is an experienced distributor or delivery person who's going to figure out a way to deliver those packages in an effective way. But the problem, unfortunately, Greg, is that the people who draft these independent contractor agreements are mostly lawyers. And for those who are lawyers on this call, you'll recall that starting from the first day in law school, when you were told how to draft a document, you were taking direction and control over the relationship and giving your client as much of the opportunities to make sure that things were done in the way in which the client wanted it. Independent contractor relationships are just the opposite. You're not supposed to take direction and control, but rather you're just hiring someone to perform services in a manner that conforms with industry standards. And the more you tell that person how to do the job, the more likely you'll end up like FedEx, which was determined by the Ninth Circuit and the Seventh Circuit as a matter of law, to have created employee relationships, not independent contractor relationships.
So let's tease this out a little bit. It's all the rage now in the practice of law to have inside general counsel specify how they want the work performed, who they want to do it, whether it's an associate, whether it's a partner, et cetera. Does that level of control, where they are drilling into what would otherwise be the proprietary control responsibilities of a managing partner, implicate the fact that perhaps that client has now employed those lawyers?
Well, whenever you tell a lawyer or anyone how to do the work, you've crossed into the realm of employee classification. If you're going to exercise direction and control, it needs to be limited, and it needs to be only that direction and control that, quite frankly, needs to be undertaken in order to fulfill the business objective. Very few companies have figured out how to accomplish that. One of the things that we spend a great deal of time on, Greg, is actually working with companies to evaluate their level of compliance, and then after we see that they are not operating at a peak efficiency in terms of compliance, restructuring and redocumenting the relationships so that they are dotting their I's, crossing their T's, and are enhancing their independent contractor compliance to the fullest extent they can.
All right, so let's shift gears a little bit and focus on the Department of Labor's administrator of wage and hours and how they have taken up the mantle of regulatory enforcement with respect to misclassification of employees as independent contractors.
Well, Greg, last summer, the Wage Hour Division Administrator, David Weil, issued an administrative interpretation that received a great deal of press. It basically said that there's a lot of independent contractor misclassification going on in this country, and here is a 6-part test that we're going to use at the Department of Labor to determine whether someone is properly classified as an independent contractor or not.
This is the so-called economic realities test?
That is precisely it, and that's the test under the federal law. The only problem is that Dr. Weil did not quite give what I would say is a fulsome articulation of the economic realities test, because the courts have made it very clear all facts that relate to the independent contractor relationship should be and can be looked at to determine whether someone is an employee or an independent contractor.
So how does this juxtapose with the traditional IRS 20-factor test?
Well, the IRS test is a more fulsome test. And even though the IRS has, sort of like abandoned on one hand the 20-factor test and articulated in a 3-factor test that has 20 total factors, it's still basically the same 20-factor test. The IRS test is generally regarded to be far more capable of being complied with than the economic realities test. And in fact, you get court cases that say, we recognize that if we would apply the IRS test here, these individuals would be independent contractors. But under the economic realities test, they're employees.
So we could potentially have a situation where one federal agency, the IRS, treats them as ICs, and another federal agency, the Department of Labor, treats them as employees?
Yes, it happens not infrequently. So what is a company supposed to do when they're faced with a situation where they have differing tests at the federal level as well as at the state level?
Well, I guess the IRS wouldn't care. So you go to what I would call the greatest common factor, right? You go to the more stringent test and you apply that and you say, okay, if they're an employee under the more stringent test, then they're employees.
Greg, that's precisely what we do, and for the very reason. We always try to comply at the lowest common denominator, the toughest, most stringent test, except for those few states that are so inhospitable to independent contractors that no one could possibly comply with them. In those instances, we advise clients to wean themselves out of that state and not use independent contractors there, or to attempt to only use employees in those particular states. There are a few of them, like Massachusetts. There's some other tough states, but Massachusetts is the one that has clearly the most stringent test of all. But you can't operate your business and design your business for Massachusetts, because you'd be eliminating the use of independent contractors for the most part if you went to that low a level.
So what are the 6 economic reality factors?
Well, the 6 economic reality factors are those that can be found online, but I'll tell you what I can recall off the top of my head.
Okay.
1, the relative investment in the amount of the equipment that, for example, the independent contractor has versus the company. Greg, that's a loaded question. Of course, the company's going to make more investment than is an independent contractor. But let me just say that where an independent contractor is buying their own truck, okay, that's pretty substantial. But where an independent contractor buys, for example, if they are in IT consulting, special software for, what they have to use, I mean, we're adding up under $10,000. Most courts would say that that's an investment. Question is it substantial enough? I think basically it's, a foregone conclusion. The way that the administrator has articulated that they want to put the relative amount of contribution, investment. And so that is, in my view, something that the courts are not looking at the same way as the administrator. Another factor is whether they are economically dependent on one particular company for their services. Indeed, that is the most important factor. It is given great weight by the Department of Labor and the economic realities test. And this is where courts deviate from the decisions under the tax laws. Economic dependence is a killer in terms of independent contractor determination under the economic realities doctrine.
Give me a fact pattern to illustrate the economic dependence test.
Okay, let's talk about that painter. Okay. Let's say you call the painter in to paint your apartment, and that particular painter comes, does a job, and in less than a week they're gone, and you don't call that person back for another 2 or 3 years. Or you can be an apartment building manager, where you have a lot of move-ins and move-outs, and you're constantly asking a particular painter to, okay, tomorrow you're painting 18H. When you're done that in 3 days, you're going to paint 18J. Then you're going to paint, 24L. And so if you would be using one person constantly, that factor would weigh against them being an independent contractor if that person is, quote unquote, economically dependent on the service recipient. So in my view, there really can be absolutely no difference between the fact that that painter is still doing the painting job the way they want to do it and how they want to do it. Just because they choose to work for a repeat customer and to have the ease of not having to look for new work, that, in my view, and many courts would agree, is not by any means determinative of whether that person should be an independent contractor. That person should be an independent contractor. The fact that they're providing services for one service recipient should never be, in that instance, a dispositive factor.
Unless, of course, if the painter is running a quote-unquote business, let's say as an LLC or a corporation, and he has 2 or 3 other painter helpers who work with him, and he has a contract to paint every unit in that particular building. And then he's got a contract to paint, some other building. That is building the case that he is, in fact, an independent contractor and not an employee.
Right, and those types of folks would never be the subject of independent contractor misclassification because they have a business, they have other workers, and they themselves cannot be, therefore, employees of somebody else. They're employees of their own company. So you hit the nail on the head with that, because anytime that you're dealing with a business where there's several different service providers, there is not going to be, in all likelihood, a finding of independent contractor misclassification. It really applies to individuals providing services, either in their individual capacity or in a sole proprietorship capacity.
So in that instance, we have the bona fides. We have someone who actually intended to create a separate business, and they're just doing what they do as their business. But obviously, you could see if it were that easy to defeat the misclassification rule, firms would be setting up help agencies internally where all of their independent contractors would have their nexus with that help agency, and the help agency would then provide the workers as needed on a contract basis to the enterprise. I'm assuming that doesn't work, that it's too easy to defeat the rules. Those people would be viewed as employees of the help agency, and then you have a whole other set of regulations that needs to be put in place. Right?
As long as they're being treated by employees by some organization, like a staffing company, no one's going to have problems. There won't be any issue of independent contractor misclassification. It's only when you're 1099ing a person and they're the one providing the services where this issue arises. Now, just so that you can, be comfortable in this area, Greg, because you've identified, you've drilled down very nicely here, but just because someone is an LLC doesn't mean that the courts won't pierce the IC veil. There have been many cases, including the FedEx case, where some of those distributors, some of those drivers or actually have their own LLCs, and the courts disregard that. They say it's a sham, especially where the company requires them to become an LLC. If they become their own business and have other folks who are providing services to them, then in that instance, they're not going to be an independent contractor on this classification issue.
So let's talk about some other implications of the independent contractor status. What about employee security or, consultant security? Do I have to worry about, does an independent contractor have the same duty of confidentiality, for example? Or what about work for hire rules with respect to the development of intellectual property? What about as an employer, my very special secret sauce, which makes our firm unique from any other firm?
Well, when it comes to independent contractors, they're not protected by employee work for hire, and they're not protected under the employee duty of loyalty doctrines that protect all employers. And therefore,
explain what those two doctrines are first, because I think it's important for people to understand that.
So for those of us who are employees or who employ others, we know that there is a duty of loyalty on the part of employees not to act in their own best interest, but rather to act in the best interest of the employer, of the company. It's a fiduciary duty. All 50 states recognize it. And if you deal...
You mean all the way down to the lowest level employee?
Even the person in the mailroom. And everyone in between. It's a duty of loyalty. That means that if you act for your own benefit and not in the best interest of the company, you will be subject to exposure. And it is akin to a fiduciary duty, essentially. And under that employee duty of loyalty, if you employ someone, you don't have to even have a confidentiality agreement because the law implies that you're not going to disclose confidential information and trade secrets. But if you have an independent contractor, there's no such duty of loyalty at all. Then you need to actually have legitimate confidentiality agreements.
So aren't they covered by the employee? Oh, wait a minute. They're not covered by the employee handbook because they're independent contractors. And so therefore, they write their own ticket. They can come in. If you give them access to, and they're working side by side with an employee, theoretically, they could walk out with the secret sauce.
Well, indeed, it's not uncommon, but it's no more or less uncommon for an independent contractor to do that than an employee, but you have rights against an employee, whereas the only rights you will have against an independent contractor, if you give them access to your secret sauce and you don't have an agreement that says that they will respect that. So in other words, if you bring somebody into your shop as an independent contractor and you don't have a confidentiality agreement with that person, you're exposing any of your trade secrets to walking out the door, and you don't really have any rights to that because you've given that independent contractor access to it. They've seen it. They can either look at it or they can take it with them as part of what they're doing, and you have to actually have a way to get that back and to prevent them from using that confidential information. And that's what you have to have at a bare minimum anytime you have an independent contractor and you expose them to your confidential information.
So law firms that are acting as independent contractors, obviously for clients, they have canons of ethics and they're limited in what they can do with client information by the nature of their license. Accountants have similar confidentiality and protection requirements. Investment managers who are CFAs, for example, are subject to the rules of the CFA Institute that they can't steal things even if they are acting in an independent contractor capacity, at potentially losing their designation. So what we're saying here is, and this is a very, very important point, the expediency and the cost savings that you may get from and it may be ephemeral, we don't know, but cost savings you get from designating someone as an independent contractor comes with a very high cost, potentially, because you no longer have those common law protections that you would have with an employee who's subject to that fiduciary duty. You don't no longer have an employee handbook that would cover the activities of that person, and therefore can't point to those things that you would with an employee. Everything is going to be defined by the nature of the contract.
That's precisely correct, Greg. But you can protect yourself with a properly drafted agreement that does retain the confidentiality of the information that you are giving the independent contractor exposure to. But that also comes with certain limitations, and I know that Laura is going to go into those because you need to take certain steps to make sure that you are protecting your confidential information and not making it available without reasonable efforts to keep it confidential.
Rich, tell us about Pepper's IC diagnostic rules. What are they?
Well, Greg, we were talking about dotting your I's and crossing your T's, and so what we have done at Pepper, since we've developed the independent contractor compliance practice back in 2010, is to figure out diagnostic tools to assess companies' levels of compliance with the independent contractor laws. We go over probably north of 48 different factors to look at. Even though you talk about the IRS looking at 20 and the Department of Labor looking at 6, we look at dozens of different factors because the courts say they will look at each of those that pertains to the independent contractor relationship. We examine them and then we determine how do you enhance your compliance. We use IC diagnostics by looking at those 48 factors and then retrofitting that relationship into an independent contractor structure and then documenting it. And that's what we do with IC diagnostics. We structure, we document, and implement the independent contractor relationship so that it complies with all the different federal and state laws. Now, one of the things that is most, engaging about this roundtable, to the extent that there are hedge fund clients or other, financial service industries, well, there's two parts of independent contractor misclassification that is applicable to those types of companies. First is, who are they, what companies are they investing in? Are those companies, do they have an exposure, material exposure to independent contractor misclassification? Are they built on business models, the potential companies that they're investing in, that are reliant on independent contractors? And if so, have they complied with independent contractor laws? We've just been asked in the recent past, and we've asked many times before, to examine, in effect, to do due diligence of companies. And one of the areas...
You're talking about portfolio investments. Before a hedge fund or a private equity fund makes an investment in a portfolio company, one of the things that they should be thinking about is whether or not that portfolio company has misclassified workers, and that where, they're showing and becoming the darling of Wall Street because they're showing great earnings numbers, perhaps those numbers are not quite what they should be because they have a misclassification problem, and we have an inchoate liability, is what you're saying, right?
That's precisely it, but then determining and doing the due diligence to determine whether they have that exposure, and if so, how much is that exposure?
So a prudent investor, being the hedge fund manager or the private equity manager, says, well, before I'm going to invest in your company, I'm going to unloose the hounds of hell and make sure that this particular portfolio company, isn't having this great value or this great multiple applied to it because it has not been doing what it should be doing with respect to its employees.
Greg, you hit it squarely on target. You don't want to make an investment in a company that has an employee, an independent contractor model without doing due diligence to see whether the model is compliant with current federal and state laws. If you do so, you're investing blindly without knowing what type of potential I would say liabilities that company may be facing in the near future.
Yeah, and of course, from the securities point of view, if that company has hidden Fair Labor Standards issue or has hidden a IC misclassification issue, that becomes a very big issue under the securities laws, because the sale of those securities, even in a private placement, is still subject to 10b-5 and Section 12 and all of the other rules against material misstatement or omission of material facts. So it would seem to me that getting a representation from the company, no, we have properly classified our employees and independent contractors, isn't enough. You have to go one step further and make sure that the value you think you're buying will not be eroded by a misclassification determination.
Well, Greg, unless you have active litigations that are somehow listed, for example, in a document that was on file with the SEC, most companies are going to say that they are fully in compliance with all federal and state wage and hour laws. Many of those companies are not even aware that they have this issue. Those companies that tend to become aware of it when they get sued, because if they were aware of it earlier, they would take action to enhance their independent contractor compliance, with one exception, Greg. We have found so much in the way of, I would say, corporate inaction, because they're saying, well, we know that we have this potential issue with independent contractors, but everything is going so well, let's just continue it until, if and when we get summons a complaint from a class action lawyer or an audit, from the IRS.
Yeah, but again, for those portfolio companies that may be on the line, or lawyers who represent them, seller beware here. The investors know this issue. They are not ignoring this issue because of its potential to significantly erode value, and they will put you to your proof and ask that you can show that you have properly classified the employees or independent contractors. Rich, I'm going to shift gears real quick here. Yesterday, the Department of Labor issued the long-awaited definitions and delimitations for exemptions for executive, administrative, professional, outside sales, and computer employees. It is 317 pages long, so I'm sure you read it and digested it all in the last 24 hours. But in 30 seconds or less, what exactly did the Department of Labor try to do here?
Well, Greg, you're referring to what is commonly referred to as the new overtime rule that the wage and hour division of the Department of Labor, U.S. Department of Labor, issued as regulation.
Now, of course, if somebody's an independent contractor and they're properly classified as such, they're not subject to these new rules, right?
That's correct.
All right, so that increases the stakes, again, for why firms are going to try to go down the IC route. But go ahead.
You must be reading the condensed version, because the one that I saw that the government issued is 509 pages. The Cliff Notes of edition you read.
317, yeah, well, okay.
Let me just say that deals with the issue of exemptions under the overtime rules.
The salaried workers are not subject to overtime, but wage and hour workers or hourly workers are subject to.
Well, but the ones who are not subject to being paid overtime have to be properly classified. They have to be properly classified as executives, administrative, or professional employees or outside salespersons.
So what we've done now is we've said if we go with the least common denominator, greatest common factor, I forget which third grade Venn diagram we should be looking at here, but whichever one it is, and we say, okay, we're going to classify people as employees because that's the safer route, we now have a second level determination that needs to be made under these new rules as to whether or not those employees are properly classified as eligible for overtime or salaried and therefore not eligible for overtime.
That's correct. Now, you would think, Greg, for example, folks who are very bright and do a great job for hedge funds and as analysts, they should be professionals. They should be something, but many of them are not exempt. You might be able to put them into executive exemption if they're supervising other people. You might be able to put them into an administrative exemption if they have certain responsibilities and are making certain decisions So, for example, a manager who's picking making the final decision for the stocks and the equities that they are going to invest in may well be exempt as administrative, but just a good old-fashioned, hard-nosed, talented analyst
may be subject to these rules.
And an analyst like that might be pulling down a very fair amount of compensation. And if you're going to start to work that person more than 40 hours, and some of them work many more than 40 hours, your overtime rate is going to be off the charts.
Does somebody who has an advanced degree or a special designation, does that mean anything here? Like if somebody is a CFA or an MBA, does that change the determination?
MBA doesn't. Lawyer degrees, accountant degrees, people like architects, for example, are all considered professionals. But the word professional does generally require advanced educational degrees, but an MBA is not going to do it.
Interesting. All right, I want to give the remaining time here to our other guest, Laura, who's going to talk about employee theft of financial IP and how a firm can protect itself with respect to that. What happens when an employee leaves and the employer believes that, or an independent contractor, if we can force them into the other category, that an employer believes they've walked away with the secret sauce?
Sure. Well, there's a couple of things, since we were talking about whether you're an employee or an independent contractor, and that can be subject to debate or court challenge. What you want to do when you set up, and especially for intellectual property, access to that secret sauce, you want to make sure you restrict the access to things you can control. So don't let your independent contractor bring their own laptop to access.
So bring your own device is not a good idea, huh? iPads, laptops, cell phones? From
an IP perspective, no. Bring your own device, despite how popular those policies are today, if they are capable of storing information that the company can't access without proper agreement, you could be subjecting yourself to, opening the back door to your IP.
Yeah, and once again, bring your own device was developed by the CFO suite, not the IT suite, because it was a cost-saving measure. They wanted their people to have devices, but they didn't want to incur the cost.
Exactly. And there are software out there. It's not impossible to protect your IP in those circumstances. There are different software programs out there that can put partitions on these devices so that if, for example, you terminate an independent contractor or an employee from headquarters, so to speak, you can turn it off and completely wipe anything that was on their machine. Most, however, bring your own device programs, policies that companies implement do not partake of that software. They just allow, on my little iPhone 6 Plus here, allow me to access my company email through this device with no partition at all.
So your company email gets commingled with my personal email, and as a result,
if I want to send
Hillary Clinton all over again.
After the secret server under the desk,
right.
from a virtual perspective, absolutely. And that's why you need to put all of the precautions in place. Make sure that the independent contractor is subject to the same confidentiality obligation as the employer.
So we have a number of scenarios in the materials here, and if those of you following along, Scenario 1, a Wall Street analyst steals trading software over a period of 3 years by downloading onto flash drives and uploading to his personal email account. Can you give us a little bit more color on those facts?
Sure. I mean, when most people, when they're looking at IP theft, think of the Coke formula and the McDonald's French fry recipe. But it can be as simple as the way you do things. It can be the way you go about assembling your research in a financial institution. It could be the way you decide to set up a design scheme or something, all of which in little pieces does not seem to be important, which is how this particular analyst preyed on this was an employee in this case, his employer, by taking little pieces over a long period of time that he thought were undetectable. I just sent that one email today, and then I downloaded some code, this little teeny piece of code, onto a flash drive 1 week. And if I'm remembering correctly, it was over a 4-year period that this particular analyst was stealing the trade secrets, and they didn't even find out about it until, of course, the employee left and tried to sell it.
And he tried to sell it, of course, all put together, not in little bits and pieces.
Yes.
So the fact that he did it over a 3-year period, it was pretty clear that there was intent there.
Yes.
And that could be inferred by the fact that he would take this piece this week and the other piece next week and whatever.
Well, again, from a confidentiality perspective, he shouldn't have had any of it, right? Didn't even matter the purpose. It was a per se violation, if you will, of his duty of confidentiality to the employer. He shouldn't have had any of that outside the walls of his employment relationship.
How about scenario 2? We've got a trading analyst who's taken trading modules. He argued that it wasn't proprietary because it was based on common concepts, the old buy low, sell high.
And this is what I was talking about, not even realizing it's IP, right? It's a pattern and practice of the way you do things. And the court said, that's fine. They don't have to be unique in and of themselves, but the way you've packaged those processes or decisions together is a unique configuration, and that is IP that outside, again, this was an employee, outside the employee relationship, you should not have had access to.
But in this case, he was caught viewing code unrelated to the trading modules he was working on.
That's the way he got caught.
Right.
Because...
So they had a market surveillance or IP surveillance program on their computers where they were able, or was this caught after the fact?
It was caught after the fact, but close enough in time before much damage could be done. Most companies are worried about the Chinese hacking, right? So they've got these complex information security protocols designed to keep the outside from getting in. What this particular company did is have some monitoring. I wouldn't call it robust, but there was some monitoring. So if you tried to get somewhere on the network that you normally shouldn't be, it would send an alert. And that's what happened here. He had gathered all of the code from the places he could access and then went to a place on the network that he shouldn't have had to go there. He had no business reason to go to it. So it gave IT an alert. And that's what I was talking about before about controlling the devices. If you can control the device and the access to this intellectual property, you can set up monitoring protocols and things like that inside to make sure that no one's going where they're not supposed to be. I mean, I have at my own company, there are certain websites I cannot go to, and despite what I try to do around back doors, I cannot get to certain places from my company's network.
Now, does the fact that you even try to get through the back door?
Of course it does.
And that triggers an alert to somebody.
Yes.
Yeah. The interesting thing is I work with a lot of IT startups and especially in the fintech space, and they all trumpet that they have open, transparent working environments, and it's a very much a matrix working environment where each is collaborating on everything else. And, I feel like dad because I say to them, well, you realize, of course, that by doing what you're doing and the way you're doing it, you have no control over this intellectual property. And if you need to either get rid of someone because they've become a bad problem in your organization or they choose to leave, you've just exposed all of your fintech. And, of course, they look at me like I'm dad.
Well, it's true. Without controls, they are absolutely. Fortunately, the technology today, both at an infrastructure level, so the major data center kind of external monitoring to whitelisting of certain places on the network that you can go to and other places that you can't go to are in place. It's just important if you're putting any of these matrixed organizations in place that you spend some time on the front end planning for that IT protection so that you can, so to speak, flip the master switch at the end of the day should one of those workers need to leave. Our biggest issue today, quite frankly, is the personal computer, is the laptop. Nobody logged around big PCs, and most people didn't try and steal things off the big computers. Now, because everything can access the internet pretty much at all times, and because, I think my MacBook has 8 or 10 USB ports on the back of it, we can be moving information with a little, 50-gig hard drive plugged into the back of your Mac without anybody noticing. It could be almost completely undetectable.
So what's an employer to do?
Well, there are big, and I'm sure everybody's a la CSI, right? Seeing that we can take the computer and we can completely dissect it and take it all apart, which in some cases, when you have substantiated that theory that maybe the employee took something, is absolutely going to happen. But there's that middle ground, right, where you're either letting someone go or somebody has just been let go, and you want to know, I kind of think that they've been doing something they shouldn't have been doing with my IP. I've told them they shouldn't. I've given them a policy that said you should only store company things here, you shouldn't use your personal email, et cetera, et cetera. But proving that they were complying with your policy is often hard. There's some software, one of which RVM has developed, that allows you to get I'll call it a quick peek into what the employer was doing on that machine. So it's simple USB, you can plug it in, and what it will give you is basically a spreadsheet with a bunch of tabs. And it'll show you what that employee was doing on their machine. What websites were they going to? What documents did they download onto a flash drive? What flash drive it was, because it'll record the serial number of the flash drive that was actually plugged in. So if, for example, you confront the employee and say, hey, I can see that you've downloaded these 3 documents onto a flash drive. Oh, no, that wasn't that flash drive. That wasn't me. We can tell from the inner workings of the computer whether, in fact, it was that flash drive if he had, for example, since deleted it and it wasn't there anymore. So that kind of simple, quick look spreadsheet, in a lot of cases, can be used to say, nope, the employee was clean. As part of the exit interview process, we're going to do this and make sure that there was no danger of any of our IP leaving. If you find something suggestive, and I think in the materials I did some funny stuff on my own machine and then ran the tool. So you see that I have a document called, super secret confidential stuff that was on my desktop that I downloaded to a flash drive. And when I ran this program, it picked it up. I also decided to open my personal email because I went through a back door in the company, even though I can't get to my Hotmail account. And I emailed the document to myself. I was able to see from a timestamp perspective that I uploaded the document to my personal email, that I went to my personal email, and that I sent that document out. So those are the kinds of pieces. It's, as I said, a quick peek. Is it, quote, forensically sound? Yes, it's forensically sound. It can be self-authenticating as far as the material it finds. Would you want to, of course, take a much deeper dive if you were trying to prosecute this kind of stuff? Of course.
Well, let me turn it back to Rich for a second. Rich, I know we've worked a lot with RVM, and you get a data file like this that shows there have been all these downloads to USB, to different USB keys, or that emails have been sent with files. What unfolds next? What's the next step in the litigation process with this employee?
Well, Laura identified it extremely well when she talked about one scenario where the person was involved in an area of the business where they shouldn't have been involved in. And so certainly there are people that if companies allow them to take work home with them and to download something onto a thumb drive so that they can use it in their home computer, that may be perfectly legitimate. So you can't jump to the conclusion that that's not correct. However, having worked with RVM, we're able to see things that the employee doesn't even know are still on the computer. They thought they deleted. Like, for example, on one of your things here, Laura, you have LNK, which I refer to as link files. And I didn't even know what a link file is. And some of the folks at Laura's company told me what that actually stood for, which was things that had been taken off the internet or links, quick links to something else. I think it's probably kept in your RAM memory. And therefore, it was there and the employee didn't even know it was there. And we're able to determine, hey, they actually took something that they weren't supposed to have accessed. A customer list of all the different customers for the company, many of which they had nothing to do with. And so the important thing really is to make sure that when people are exiting the company, you're doing something in a rigorous way that I can't tell you about, but Laura could, in order to make sure that they are not leaving or have not taken things just before they gave notice. That's the area of time where companies are most vulnerable and that we have to run into court after getting the help of someone like RVM to show that something has been removed improperly.
So we have a few minutes left, Laura. What's your primary recommendation to people who employ employees and independent contractors?
If you've got IP that can be accessed via a device, do everything you can to control the device. Do not adopt a BYOD policy unless you're prepared to invest the time, energy, and infrastructure around putting one of those partitions in place so that you can completely control that information, and put it in an active monitoring program that should be publicized to all employees and independent contractors that we take our protection of our information seriously. Everything you do on the network will be monitored and can be monitored. And unfortunately, if you find some bad actors, make an example of them, because that's the best way to stop future activity from happening. As I tell my teenage daughter, you can't hide it if you've done it on a computer or an electronic device. I can find it. The question is, will I, and will I find it?
Well, I don't think I'd want to be your son, given the fact you have all these tools available to you.
They're not terribly happy with me now.
Rich, any closing points or remarks?
Well, I would like to, in closing, indicate the importance of IP both for independent contractors and employees. But I think it's fair to say that virtually every company is giving their employees or independent contractors in some instances access to IP. That being the case, there needs to be something else that needs to be done so that there can be mechanisms in place. These are not things that lawyers can do. You need a company like RVM who has that type of infrastructure that it can build in. And then in addition, once someone leaves, if there's suspicious activities, lawyers can't do it alone. But also one very important piece I learned from RVM, do not have your IT department look at emails and other stuff. Do not contaminate that work. Grab the hard drive. Give it to a company like RVM. They will make a forensic image, and then no one has touched the document.
Yes, this is going to be your best evidence.
It's a basic chain of custody.
Absolutely.
Yeah, and that's actually a very good point for our listeners. Your own IT people may be your worst enemy in trying to prove a case against you.
And often are.
Because they do something with their diagnostic tools that ends up tainting the evidence. So you need to figure out, as the employer, what you're trying to accomplish, and if you're using independent contractors, you want to make sure that you have those contractual protections. You're vulnerable either way. And if you're in a matrix environment or if you're in an open, transparent environment, the likelihood is greater that someone is going to try to take that for their own purpose. Anyway, we are at the end of our time. Thank you for your attention, and we look forward to speaking to you again in September. Have a great summer, everybody.